We have an agreement, Your Honor.
All right. And what is that agreement?
Whoa, hold on. Right out of the gate, we're cutting into a tense moment. This clip jumps between two separate, high-stakes hearings. The initial exchange about an agreement and the mention of an 18-year sentence hints at the brutal reality of the case. Intoxication manslaughter. Keep that in the back of your mind. We're about to see the drama behind a plea deal that has already been reached and how the court navigates the aftermath of this tragedy.
I believe it's, hey, could you repeat the agreement for the court? Put it on the record.
With the vehicle or please make copies.
All right. So with that, there will be copies. Sir, are you okay? The court will sentence you to 18 years in the prison.
Same date on each.
Okay. All right. Is there anything else?
That's all we have.
All right, Mr. Daniels.
I've been straight up with you. If I messed up, I messed up, and I tell you that. And I'm doing everything I was supposed to. Last time I seen you, you were gonna let me go to the Army. I just missed one. You wait.
No, I mean, I told you, yes, sign up for the Army. If the Army accepts you,
And I have the number. I have the number right there for them.
And it never happened.
No, because they.
Court will sentence you to 3 years deferred adjudication.
Sorry, I thought it was two.
All right, so let me explain something to everybody.
San Antonio police accused 56-year-old Marlon Daniels of crashing his car into 39-year-old Vanessa Ramos and 5-year-old Solomon Lopez last night. This was on Stone Oak Parkway, not too far from Highway 281 on the far north side. The mother and daughter were on a sidewalk. That's when police say a driver jumped the curb and crashed into a utility pole.
Police tell us that the driver continued down the sidewalk and struck the mother and daughter. Officers accused Daniels of driving fast before the crash and was found to be intoxicated. He was arrested on 2 counts of intoxication manslaughter.
Could I have parties announced for the record for the state?
Jason Garahan, Your Honor.
Defense?
George Sharman on behalf of.
This is a motion to alter and amend conditions upon bond. Now, for a legal breakdown, Mr. Daniels has been arrested on 2 counts of intoxication manslaughter, a serious felony. He's out on bond, but his conditions, like where he can go, are strict. The defense is trying to loosen those conditions, specifically to allow him to go to work. This entire segment with the daughter is a tactical move, highlighting his financial necessity and family support to convince the judge. Ask yourself, is this enough for the judge to risk his freedom for a job?
All right, and are you Mr. Daniels?
Yep.
All right, we're here on a motion in each of these cases to alter and amend your conditions of bond. State, have you had a chance to review the request?
Yes, Your Honor.
All right, State, do you have objections?
Yes, Your Honor.
All right. Defense, do you have any witnesses?
I have Ryan Spencer, his daughter here.
Oh, well, call your witness.
Well, I'll call Ryan.
Defense?
All right. Would you tell the judge your relationship with Mr. Daniels?
Marlon is my father.
Okay.
And do you live with your father?
I do.
Who else lives there?
I have 2 little children, my 8-year-old and my 6-year-old, myself, and then I'm currently pregnant.
Now, does your father have a job?
He does.
Is he currently employed?
Currently, yes.
Now, is he able to work from home?
Right now, they're not allowing him to. They just need understanding that he's able to go to work physically, and maybe something from home could be worked out eventually. I'm not too sure.
Are you available to give him a ride from your house to work and then from work back home?
Yes, yes.
All right. Are you asking the court to allow you to do that?
Yes, please.
Do you have a vehicle?
Yes, I do.
Does it have an ignition interlock in it?
No, he doesn't.
Would you, now does Mr. Daniels have access to that?
We live together. It's at the home. As far as him driving it, no, but we do live together, yes.
In order to get the opportunity for you to drive him to work, if the court so requires, would you be able to put an ignition interlock in that car?
If that's what's deemed necessary, yes. Yeah.
What are you asking the court to do for him right now?
To allow him to be able to go to work physically. I believe that is the only thing the employer is preventing him from being able to actually go into office or work at all. So just for him to be able to go to work.
Now, why is it necessary for him to go to work?
Because I mean, he accumulated bills. It doesn't stop. Nothing has stopped. I can only help financially so much. I know going to work would help alleviate the stuff that has came up and help assist with what's going on currently.
Can you support yourself and him?
That right there is a key to the defense's argument. I can't do that. His daughter is admitting she cannot financially support herself and her family without her father working, even with him being a government employee for the Social Security Administration. This testimony makes the need to go to work feel urgent, but the judge still has to balance that against public safety, especially given the nature of the crime, DWI.
He doesn't work.
I can't do that.
So is it necessary for him to go to work and be paid by Social Security Administration?
Yes, it is.
Is that where he works?
Yes, it is.
He's a government employee
Yes, he is.
and he currently has a job.
Yes, he does.
Has he used his leave from his job? Does he have
Yes.
any leave left?
The only leave that I know of is his sick leave, which they are not allowing us to utilize.
All right. And if he were allowed to work, would you be able to tell the court that you would make certain that he doesn't leave the house except only for work?
Oh, definitely. That's the understanding. He's home now. If he is granted permission to go to work, the only place that he's going to be allowed to go is to work, to and from work. So yes, that would be what we're going to do.
Now, does he have an ankle monitor?
Yes, he does.
Is that a GPS monitor?
Yes.
Is it expensive for him to have that monitor?
Yes.
All right, so let me just stop you right there. State, do you have any objections to him being employed and going to work?
Judge, I was misinformed. I was looking at something else.
Okay.
So that's what I was looking for. I don't think at this point the state would be opposed for him to be able to work. But we would be opposed to any vehicle being at that household that didn't have ignition airlock that he possibly would have access to.
All right, so I like to get to the point sometime because maybe a lot of testimony is not needed. But if more testimony is needed, you all just let me know. So is this the only vehicle at your house? You only have one vehicle?
Yes, ma'am.
All right, so that vehicle is going to need ignition interlock on it. All right, so that's off the table. So
This is vintage courtroom drama. The defense thought the state was opposing any employment, but the state's objection was just about the ignition interlock device on the vehicle. This is a crucial clarification. The state is okay with him working, but they are drawing a hard line on anything that could lead to him driving again. The judge correctly points out that testimony changes things, and the objection is partially withdrawn. Big win for the defense. He can work, but the freedom ends there.
All right.
next
now,
thing,
Judge,
employment.
I'm sorry to interrupt, but I had asked them about that and they told me they opposed.
Well, here's the thing. We
Okay.
are where we are now.
All right.
Everyone, you know, sometimes people hear testimony and things change. Sometimes what I'm going to do originally, once I hear different things, maybe, you know, what I'm going to do changes. So, you know, when you're getting what you're asking for,
Oh, I'm not a,
you know, let it lay there.
yes, ma'am.
So they want you to have ignition interlock on the vehicle. Are you going to be able to do that?
I need to understand what that is and what I'm going to be responsible for.
Oh, well, it's a device that's placed in your vehicle. And anybody who's driving that vehicle, they have to blow into it.
Okay.
Now, state, if that vehicle has ignition interlock on it, are you okay with him driving or no?
Oh, no.
All right. So even though your vehicle will have ignition interlock on it,
Okay.
he's not allowed to drive it.
Okay.
All right. So there's to be no driving. Now, the next thing with regards to the GPS, do y'all still want him on GPS? All right. Counsel, I understand why they want him on GPS because it's the nature of the offense.
I understand. We're just asking if you would waive the fees for him because they're having some difficulty.
All right. I will tell you what, I'll put in there to waive the fees or defer the fees. The problem is these are third-party contracts. So I have no authority to tell them the fees must be waived. So I'll put in there that the fees are deferred or either waived. If they waive them, great. If they just defer them, great.
Okay.
There's supposed to be a monitor that's free. I don't know where that monitor is. So I've been trying to figure out where's the free monitor and who has it. But that's where we are. So he's going to be allowed to work. State doesn't have any objection to that. There has to be ignition interlock on the vehicle. He has to have GPS. The GPS fees, I'll ask that they be waived or deferred. Anything else?
That's all we want, Judge.
All right. See how this hearing ends very quickly on a, Friday's Eve. Yes.
Okay, so with the interlock, is that a fee as well monthly?
That is a fee.
Am I able to request a waiver on that one too?
I'll ask that it be waived or deferred, but I can tell you right now, what I'm going to get is I'm going to get an email from that company and somebody's going to say, Judge, you're not allowed to waive fees on that. I know I'm not, but I write it down anyway, because maybe some person will say, hey, we just found the free monitor.
Gotcha.
But you will have to pay for it though.
Okay. But as long as he's able to go to work to help assist, that's fine.
Yes.
Okay.
All right. Thank you so much for coming in.
Thank you.
Judge, would there be a written order for pretrial services? Okay.
Yeah.
Okay.
All right, Mr. Daniels, if you'll come forward, please. Yes.
Okay.
Can you raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Marlon Demetrius Daniels.
All right, so Mr. Daniels, you understand that you are not allowed to drive at all. Do you understand?
Yes, ma'am.
So if it's discovered that you're driving, a motion is going to be filed by the state. You'll have to come in and we'll hear that. You understand?
Yes, ma'am.
Is there anything that you do not understand about the court's orders?
No, ma'am.
All right, so you're allowed to go to work only. If something else comes up and say you want to go to the grocery store, you have to come back in and get an order for that. You're only allowed to leave the house to go to work. Do you understand?
Yes, ma'am.
All right. Thank you all.
We skip ahead, and after a medical scare, the man almost hyperventilates in the courtroom. Can you even imagine that stress? The focus shifts entirely back to the crime. The defense and prosecution confirm that Daniels took an 18-year plea deal. The judge explains the high risk of a jury trial for a military veteran with no prior serious history. He could have gotten less, but he could have gotten more. By pleading guilty, he accepts responsibility and gains certainty. This is the core trade-off of almost every plea deal.
Thank you, Judge. I guess we're excused now. He has to go.
Yes.
Because of pretrial service.
Daniels?
Yes, ma'am.
All right. Defense has filed a motion for release of personal property. State, have you a chance to review that?
I reviewed it last week, yeah.
All right. Any objections?
Yes, Your Honor. At this time, it's just, in just an abundance of caution, the state has not reviewed the possible items that would be returned. I know that there's some identifying papers and there's other objects that we may not be opposed to necessarily. I believe Mr. Sharman said something about a scooter of some sort for getting around.
Let me go through the list and you just tell me what you have objections to, then I'll hear it. All right. His wallet.
Objection.
All right. And what is the state's objections to him receiving his wallet back?
Identification purposes, Your Honor, for him being in the vehicle.
All right. So is it possible for parties to make a copy of the items that are in the wallet, make a copy of his driver's license, make a copy of the VA documents, have the defendant and defense sign off to the fact that these are copies of the wallet, the driver's license, and the VA documents that were in the vehicle?
I'd be fine with that, Judge.
Yes, that's fine with the state.
All right.
As long as we can do it soon.
Well, that's something you all have to work out amongst each other. So the wallet, the driver's license, and the VA documents will be returned once the state has made copies of those. Mr. Daniels, can you raise your right hand for me? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do, ma'am.
You can lower your hand.
Thank you.
So you understand the wallet, the driver's license, and the VA documents will be returned to you once the state is able to make copies of those documents?
Yes, ma'am.
And you understand that your attorney has agreed that you will sign a document stating that the copies the state will make of the wallet, the driver's license, and the VA documents, you will sign a document stating that those documents, the originals, came from the vehicle, whatever part of the vehicle, and that you agree that they will have been found in that specific place.
Yes, ma'am.
All right. Personal documents.
I don't know what the personal documents are.
Badge that you.
What are the personal documents?
Garage door opener, key card for work.
All right, just 1 second. Let's slow it down.
Right now.
So the garage door opener,
Key card for work.
key card for work,
And there's a gym bag and it has some miscellaneous items in it.
gym bag. Well, here's the thing. We have to be very specific.
Okay.
What's in the gym bag?
Probably pencils, pen, an air pump.
All right. So with regards to the gym bag, the court is not going to agree to release that to you until people have had a chance to view what's in the gym bag.
Okay.
All right. Garage door opener. Any objections? Okay. Key card from work.
Maybe just a copy of the judge. I don't know if it has a photo ID or anything.
All right. So the key card from work.
It doesn't have photo ID, ma'am. It's just a regular.
All right. So what we'll do is the state will make a copy. Both defense and you will agree that that is a copy of the original that came from the vehicle. All right. So those will be released. Air pump.
So for basketball or something sort.
What is the air pump?
The air pump was basically for when I have flat tires, emergency purposes.
No objections to that.
Okay. Clothing.
I had two jackets, winter jackets, one hoodie, they're both hoodies. One's a zip up hoodie.
Winter jacket and hoodie. State, is that an item that you all can have somebody take photos of?
That's what I was going to suggest, Your Honor. Just we can take photos of those items.
All right, so they're going to take photos of those items. And again, counsel, and you will stipulate that those items were found in the vehicle?
No problem, ma'am.
Okay.
Sorry.
Documentation from glove box.
I believe it's an owner manual. Might be a measuring tape, tire gauge, maybe registration and license, not license, but insurance paperwork. Can't think of anything else that might be in there.
All right, the owner manual.
We'd like that to stay with the vehicle.
All right, so the owner manual is going to stay with the vehicle because really, what can you do with an owner manual if you don't have the vehicle? With regards to the measuring tape.
No objection.
Okay. Tire gauge,
No objection.
registration, insurance, and paperwork copies.
We'd like to at least keep that with the court. I'm sorry, with the vehicle, or at least make copies.
All right. So with that, there will be copies. Sir, are you okay?
Just breathing right now, ma'am.
Okay. Do you need to have a seat?
I think I'll be fine.
Just 1 second. Deputy Laura, we're going to get him a seat.
There he is.
All right. Yes. Let him have, sir, have a seat.
Thank you.
And just take deep breaths. Do we need to call somebody for you?
No, I should be fine, ma'am. Just hyperventilating.
All right. Do you need any water?
Yes, please.
I thought I had a bottle.
Quiet down, please. We're on record.
Could somebody see, do we have cups in the back to get him some water? All right. Thank you.
I get some food, sure.
And then State, do you have any objections to the scooter from the trunk?
Is that this a scooter like
It's
for injured legs?
Yes.
Okay. No objection to that. No.
All right.
Again, I'm sorry, just to take photos of it.
Okay.
I believe there might be photos, but I have not reviewed that to make sure.
All right. So this is the court's rulings. With regards to the wallet and the contents of the wallet, this and the driver's license, the VA documents, the state is going to take photos. Both defense and Mr. Daniels are going to stipulate that those are copies of the original, and you're going to stipulate to the location it was found in the vehicle. The air pump, the state has no objections. 2 jackets, the state will take photographs of those. Mr. Daniels in defense, you will stipulate that those are items that were found in the vehicle and the location of it. Documentation, the owner manual, that will be denied. Measuring tape, the tire gauge, state if you want to take photos of those and then give them.
Yes, Your
The registration insurance paperwork, the state will make copies of those. Both the defense and Mr. Daniels will stipulate that the copies are the originals and to the location where they were found. Scooter from the trunk of the vehicle, state will take photos, and both defense and Mr. Daniel will stipulate that those are photographs of the originals and where they were found. Is there anything else from either side?
Nothing from the state, Your Honor.
No, ma'am.
Anything else?
No.
Any other items?
If there is, I can't recall now.
All right. So, and counsel, if you all want to make arrangements for you and maybe the investigator or somebody to go view the vehicle, and if there's some items that is not on the list here, you can always come back to the court.
All right. I have it in there.
Okay.
I spoke to him last week, so.
All right. So I'll make notations of this, and then we'll have your client here so he can catch his breath.
Okay.
And they're going to bring him some water.
All right.
Thank you so much.
Thank you, ma'am.
Sure.
All right.
Thank you, Judge.
You're welcome.
And I'll get a copy of your order.
Yes.
For myself.
Thank you.
Thank you, ma'am.
You're welcome. Could I have a B page on this case? Because it'll be easier. In each cause, you're charged with intoxication manslaughter. That's a 2nd-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If you have a plea. All right. After viewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty in each cause number. Are we proceeding with sentencing?
I've requested a PSI on the case.
All right. What's the purpose?
I gave it to you last week.
No, I mean, what's the purpose of the PSI?
Well,
Do you not want me to follow the plea?
no, the purpose of it is for you to see the things that he's going to be doing, and it also helps to determine his, I guess, incarceration, what's going to happen to him there, and it gives them a basis of information about the case and about him.
But when he is incarcerated, they will do their process to see what would be appropriate, what treatment is appropriate for him.
I understand, but they have more things that they can do here to provide that information to the prison. And it's also a mandatory right that he has to have.
You know, I mean, if you want a PSI, of course, I will give you a PSI. I just don't understand the purpose of the PSI when you both have agreed that he's to serve time in custody.
Yes, and if you read the case law that I
No, I'm telling you, I understand that you're entitled to a PSI.
Yes.
I just don't understand the reason for it. I could see if I'm requesting a PSI because I've read the facts and maybe I'm not going to follow your plea bargain agreement, but he's agreed to prison time. I don't understand the need for a PSI. That's what I'm just trying to understand.
Right, and the point is that here locally, when they do the PSI, they have more information than the prison will have on his background, his military, everything that he's doing in the community here in his education. They will have more information to take with him to the prison. They will not have the ability to do the things that they can do here.
All right. It's the court's understanding that they do have the ability to do that. However, you want a PSI, the court will give you a PSI. Ms. Abrams, see if they can expedite the PSI. and I will give you a date. You're going to be taken into custody today. And let me call and see if I can get a date. All right. Is there anything else?
That's all we have.
All right. Thank you. Yes.
We did have.
Right. Mr. Daniels, the court, at the request of your attorney, had a PSI ordered. And Mr. Daniels, we're going to proceed with sentencing. And each of the cause numbers, you entered a plea of guilty, and the punishment is to be assessed at 18 years in the prison. Mr. Daniels.
18 years in prison for intoxication manslaughter. The judge's monologue here is powerful. She emphasizes a lack of intent, which is true, but that the outcome is still devastating and permanent. The judge follows the plea, imposing the 18-year sentence, running concurrent for both victims. Crucially, the judge recommends a therapeutic community, a residential substance abuse treatment program in prison, as a measure to aid his recovery and maintain sobriety upon release. A final thought. What do you think is a fair sentence for a crime that was not intentional but resulted in the death of mother and child? Let us know in the comments below.
I've had a chance to learn more about your background from your attorney, your military service. And I will tell you, I know that no one, at least I have yet to have someone come before me and say, my intention was to get drunk and go out and hit somebody, or get drunk and drive drunk. Nobody ever intends to drive intoxicated or get to that point, but it happens. And that's why I always try to stress to everybody, please, please, if you're going to be drinking at all, even if you think it's just going to be one drink, it's better just to have a designated driver, right? Okay. And I do appreciate the fact that you entered a plea, that you accepted responsibility by pleading guilty, and that you have not wavered and try to blame something else for this. I do note that you said that you couldn't remember, but you know it's true. And I appreciate that. Sometimes people will say, well, I don't remember what happened, so I'm really not responsible. But you didn't do that. And the fact that you entered a plea, and in each of these cause numbers, you were looking at 20 years. And I always tell people, when people go to jury trial, even when I was a defense attorney or as a prosecutor, I sometimes would have to explain to families, you don't know what 12 people are going to do, right? When you go to jury trial, you don't know. 12 people could say, you know what? This person before me is a military veteran. This person before me hasn't been in trouble. Yes, they did this, but we're not going to give them 18 years. Who knows? A jury may decide to have given you 2 years or 3 or 4 or whatever. You just never know. So for you to accept responsibility, for you to take the 18 years, knowing that by taking these 18 years, there is no appeal because you waived your right to appeal. I think that says a lot, even though I know that the family is in a lot of pain, because when you lose someone and you lose someone this way, it's not expected. So the court is recognizing that you entered pleas of guilty to each cause number, that you accepted responsibility, and you took close to the maximum sentence in each of the cause numbers. With that being said, and cause number 2024 CR 009218, the court will follow your plea bargain agreement as previously stated. When you entered your plea, the court is finding you guilty. The court will sentence you to 18 years in the prison. There's a $2,000 fine. The court will give you credit for any time served, and legally, you're entitled to any time that you have served on this case. This will run concurrent with 2024 CR 009219. I'll request the therapeutic community. The therapeutic community doesn't increase the time that you're in custody. It's merely designed to help you maintain your sobriety, address any type of mental health or substance abuse issues you may have, so that ultimately, when you're released from prison, you will maintain your sobriety. And there's an affirmative finding of a deadly weapon.
May I address the court on the matter?
Just one moment.
Yes.
And cause number 2024 CR 009219. The court is finding you guilty. The court will sentence you to 18 years in the prison, give you credit for any time served. There's an affirmative finding of a deadly weapon. This run concurrent with 2024 CR 009218. There's to be restitution of $60 to DPS for testing. And the court will recommend the therapeutic community. There's something you wish to say, counsel?
Yes, on the PSI, it said that he had the combat risen. He did not have combat treatment. So that was erroneous.
Okay.
Step number 2, it shows there were 2 priors of misdemeanors. There was only 1. And if you look at it, it's the same date on each.
Okay. All right. Is there anything else?
That's all we have.
All right, Mr. Certification.
Correct.
All right. Counsel? Counsel.
Yes.
All right, your client has been removed from the courtroom. Did you review the trial court certification of defendant's rights to appeal with him?
I did.
All right. On the record, the court informed the defendant that by entering the plea, he had waived his right to appeal, so he acknowledged that. I followed the plea bargain agreement. So because I followed his plea bargain agreement and because he's waived his right to appeal, he do not have the court's permission to appeal.
I went over that with him, Judge, so he understands.
All right, thank you. Is there anything else from either side?
Well, Judge, I don't know if Mr. Sherman wanted to bring this to your attention, but because the defendant is going to be in custody, I did see that he filed motions to remove the ignition and interlock. Your motions to...
Yes, she's already signed.
Okay, yes, I signed those, yes.
Objection to that.
All right, thank you.
And then we do have victim impact, but I'm...
All right, so who are the people here for victim impact?
There's the father...
Okay.
Well, the father and husband of the victims, and then the daughter and sister.
Okay. All right, so everyone, just give us a moment. We're going to have medical check him out to see what's going on. And then if you will be patient, we'll have him brought back out if they say that he can be brought back out. And then you can get. The court is calling 2024 CR 1359 State versus Jose Escalante. Can I have parties announced for the record?
Melissa Albin for the state.
Raymond Martinez for Mr. Escalante.
All right. And are you Mr. Escalante?
Yes, ma'am. Yes, Your Honor.
And we're here for a bond issue. Is that correct?
Yes.
All right. And State, have you had a chance to confer with the defense on the request for a bond?
Yes, Your Honor. We're recommending $30,000.
All right. And defense, do you have witnesses? I believe you were going to call him.
Just him.
Okay. All right. Could you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right. You can lower your hand. State your name for the record.
Jose Manuel Escalante.
All right. You may proceed, counsel.
Mr. Escalante, first question is, how long have you been in jail? Roughly.
Approximately a week and a half.
And at the time that you were arrested, were you working?
Yes, Your Honor.
And what were you doing for work?
Mambo's Seafood.
And what was your job title there?
Dishwasher, maintenance.
Hourly rate?
$13.50 an hour.
Did you report your probation? Have you been reporting probation up until the time you got arrested?
Yes. I've been doing everything I've been supposed to be doing.
We'll get into that the next segment.
Okay.
But they've seen you recently.
Yes.
They've tested you recently.
Yes.
Okay. Is there an immediate need for you to get out on bond?
Yes.
You can tell the judge what that is.
I just had my beautiful daughters born. My two twins. They're twins that were just born.
This month?
Yes.
And where are they?
They're in the NICU right now.
And so would you like to be able to spend time with them and make sure they're okay and help their mother, even though you've got this issue pending?
Yes, sir. It'll be a blessing.
Okay. And at the time you got arrested, did you have money saved in the bank? Was it difficult to even come up with a little bit that you did come up with to get you in front of the judge today to request a bond?
Yes, sir.
Okay. And then you're gonna have to scramble and figure out a way to post a bond if she sets one for you?
Yes.
Okay.
And I still have my job there at Mambo Seafood.
How long had you been there?
Few weeks.
Okay. And is that the first job you had in a while?
No. Yes, sir. No, sir.
So what were you doing before that?
I was doing my own self-business tattooing.
Okay. And so that's still available as well?
Yes, sir.
Okay. And you and the mother are living together?
Yes, sir.
Good terms?
Yes, sir.
Okay. So if the judge set the bond at 12,000, do you think you could possibly come up with that?
Yes, sir.
Any questions?
Just a couple. Mr. Escalante, I know you're not pleading true to anything at this time, and that's fine. But at the time of the new arrest that's just alleged in the MTR, were you working?
Yes.
And at the time of the allegations that are in the MTR, was your significant other pregnant?
Yeah.
Yes, she was pregnant. So that was before the babies were born.
Can you repeat that again?
She was pregnant on the day that you were arrested for this new number one that's alleged on October 14th.
No, ma'am. We're going back and forth from the hospital for the NICU.
So the kids were already born
Yes,
when
ma'am.
this happened.
Yes, ma'am.
Okay. Nothing further, Your Honor.
All right, I just have a few questions. So in the past, have you ever used any type of controlled substance?
In the past. Oh, but yes. The past.
All right, and in the past, what would that have been?
Xanax.
And what else?
Yes. Cocaine.
I'm sorry, what?
Cocaine. I apologize.
All right, and I think the last time you were here, you were saying you were going to go in the military and have your tattoos removed because they did it for free.
Yes, ma'am. And I was doing all that and everything like that. I had went to the recruiting office on military, and I was talking to my probation officer, and my probation officer told me to wait on that because she was going to go and conversate with him and further look into it, because when I went and told them how you gave me the permission and everything like that, they tried to tell me, oh, well, you got to go to a different branch because the quota that they met was already over with. So I had to start the quota over in November when they start the new quota, and then they'll be able to accept me and further everything else. Because you gave me that chance, and I took off and I ran with it, Your Honor, and I was doing everything I was supposed to be doing.
Your Honor, may I say something?
Yes.
Normally on a motion to set bond, I would offer you the police report of the new offense, but the court summary summarizes it. So I was just going to ask if the court would like to see that to understand the circumstances of the new allegations.
Any objection?
Bond hearing judge, so you're allowed to look.
No, I'm just, any objections?
I do object, but I understand also the rules allow it, so.
Yes.
May I approach?
I don't look silly objecting to something.
No. I always tell people to do an objection because my understanding is that this is a summary of what someone read, and it's not necessarily the police report.
Also, fair to, when I think that you are, the way it's before the court now is not going to be its time.
All right, this is what the court is going to do. The court is going to set your bond at $40,000. There's to be partial GPS for employment and medical appointments, waive GPS fees. There's to be no residing in household with minors. All right, thank you.
Will that partial allow him to go visit the kid at college?
Yes.
Thank you.
All right, the same Jose Escalante, who was placed on community supervision in 2024, CR 1359 for the offense of manufacturing, delivery, and controlled substance penalty group 1, 4 to 200 grams on May 13, 2024 for a term of 6 years. Is that you?
Yes, Your Honor.
All right, state.
Violated condition number 2, on or about the 18th day of August 2025 in Bexar County, Texas. The defendant, Jose Escalante, did then and there fail to submit to drug testing in violation of condition number 2.
How do you plead to that? True or not true?
True.
Violated condition number 2, on or about the 9th day of September 2025 in Bexar County, Texas. The defendant, Jose Escalante, did then and there fail to submit to drug testing in violation of condition number 2.
How do you plead to that? True or not true?
Not true.
Violated condition number 2, on or about the 26th day of September 2025 in Bexar County, Texas. The defendant, Jose Escalante, did then and there fail to submit to drug testing in violation of condition number 2.
How do you plead to that? True or not true?
Not true, Your Honor.
State will waive the remaining conditions.
Any objections to the waivers? Did you understand by pleading true to violation of condition number 2, the court could find it true and sentence you up to 6 years in the prison?
Yes, ma'am.
And let me see if there's a fine in this. There's no fine listed. So knowing that, do you still wish to plead true to violation of condition number 2?
Yes, ma'am.
Court will find violation of condition number 2 true. Is there a proposed agreement?
No, Your Honor. At this time, state would be recommending revocation and sentencing to the adjudicated 6-year underlying sentence.
All right, defense, what are you requesting?
Judge, we're asking that he be continued on probation pending his new number 1 and other conditions that are been imposed by the court. He's on GPS monitoring at this point. We would agree if the court would consider tracking to continue that pending the resolution of the new case. Mr. Escalante's had a really difficult last few months. He just had twins that were born in October. We're in the hospital for a while after that and barely just now getting home. And I think there's 4 other children in the house.
Yes, sir.
So there's a total of 6.
Well, why didn't he think of that before this? Because what I can tell you is according to your plea bargain agreement, the state was opposed to your application for community supervision, and they were opposed to your application for deferred adjudication. And you were given community supervision by me.
Yes, ma'am.
And now you're not following through. And that's a problem.
Yes, Your Honor.
So I don't think you should be continuing through. And this is the possession with intent to deliver, which is a first-degree felony. And none of that gave you pause to behave appropriately. And it's not as though the children that you say were born, okay, you have twins, but you had other children at home already. And that didn't give you pause and didn't make you think, I better do something because I could potentially end up in prison. Yes. Do you want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
Jose Escalante.
Yes.
I was, as far as that violation goes, I was doing everything I was supposed to be doing, especially whenever they gave me the violation for the marijuana and I came up to speak to you and you told me to give you, for me to get a prescription if I wanted to indulge in that. I got the prescription, I did my UAs, but I had to wait for the arm too. And I had got the recruiter's information and everything. I was doing everything I was supposed to be doing. It's just due to the circumstances as me getting to one spot to the other with the kids. I can't go into the thing with the kids. And then as that my fiance was in the hospital because she was a high risk due to the pregnancy. I was doing everything I was supposed to be doing, going to the job fairs, everything, working, doing everything I was supposed to be doing.
Well, I will tell you this. Both your attorney and the state asked me to watch a video, but and I watched it.
Yes, ma'am.
And since you didn't plead true to it, I'm not going to even consider it. But you haven't been doing well on probation.
May I ask what makes you say that?
Because you're here on a motion to revoke.
Yes, ma'am.
Anytime somebody's here on a motion to revoke, you know what that means? That means that they're not doing well on probation.
Because even my probation, I was doing everything I was supposed to be doing. She was telling me I was doing a good job. It's just the UA that I failed to be able to go submit. That's the only problem that I had with probation.
Prison before?
Yes, ma'am. And I'm not trying to go waste my life on that.
He's been to prison before?
This is the first time I represented him, Judge. I'm not sure about that.
Yes, ma'am.
Then, you should know.
And I've been doing everything, Your Honor. It's just I wasn't able to make it to that UA, and that's the only problem that I had. I was doing weekly UAs before making it and everything like that. It's just lately with the kids and everything, it's been a lot. And now that I'm getting everything situated, I got my own apartment, I'm doing good. I'm with my kids. I got the motion you approved for me to be with my kids, and I've been doing everything I've been supposed to be doing. I had a job, I was doing everything.
All right, again, I'm not considering any of the other violations in the motion because you didn't plead to those. But what I can tell you, first of all, is there any objection to the court reviewing the court summary?
No, Your Honor.
Could I see the court summary? Based upon this, I don't think you're appropriate for probation. Did you have a chance to review the court summary?
Yes, ma'am.
So the court is going to grant the motion to revoke, sentence you to 5 years in the prison, give you credit for any time served. There's to be no residing in households with minors. And what I can tell you in that court summary, it says that the grandparents were taking care of the children. So there's to be no residing in households with minors. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? All right, you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you're on community supervision. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney.
May I speak?
Sure.
Well, the court saying that I wasn't doing nothing, but my probation officer said I was doing amazing across the board with it. The only problem, the only mistake I had was the UA. Like I've been doing everything I've been supposed to do, Your Honor.
All right, let me just tell you, this court summary that they gave to me, let me tell you what it says. Field visit was conducted on October 14, 2025. We can go off the record. On the above date.
I prefer that we stay on the record.
Okay, we can go on the record.
You just told us you weren't going to consider anything other than what.
I'm not considering any of that, but he keeps saying he was doing well on probation. And for the record, I didn't consider this. The only thing I considered was probation's recommendation. Although both parties agreed that they had no objections to the court reviewing the entire court summary. But what I can tell you, which is not related to any allegations that he did not plead to or that the state didn't raise, there is a section in here. It says that the probationer reported his newborn twins were in ICU at Stone Oak Hospital and other children were cared for by their grandmother. That's what I meant when I said the grandparents is taking care of the child. What I can tell you is probation's recommendation for you is safety. So they want you to go to safety. So my choices for you are safety or either revocation. I don't think safety will be a good fit for you. Number one, if you have outstanding pending cases, safety will not accept you. But either way, I don't think it would be appropriate for you to leave the courtroom.
Like I've been literally doing everything. As far as when you were saying my children were with my mother-in-law, yes, they were, because I was in the hospital from 10/7, staying at the hospital and leaving them there and going to my mother-in-law's house and staying there. I wasn't residing at my house no more. Mm-hmm. And I told my probation officer that I'm in the process of moving. She's like, okay, well, when you get the address to move, you get your apartment, give me the address. Mm-hmm. I've been doing everything. I was staying there with the grandparents as well. Well, my mother-in-law as well, as far as her grandma. I was staying with her and going back and forth to the hospital, back and forth, helping them take her to school and then going back to the hospital and making sure she was all right, as well as my twin. I've been doing everything. Like, George, I've been straight up with you. If I messed up, I messed up, and I tell you that. And I'm doing everything I was supposed to. Last time I seen you were going to let me go to the Army. I just missed one UA.
No, I mean, I told you, sign up for the Army. If the Army accepts you.
And I have the number. I have the number right there for them.
And it never happened.
No, because they told me I had to wait for November for the new quota. November came and I called them and they're all for me. I just had to come in front of you and talk to you, give them your number. Mm-hmm. Your number. And I'm doing everything.
Well, for now, that's my sentence. Counsel, if he has military aspirations and they're willing to accept him, then the court will reconsider. If there's no objections to the state, with the court reconsidering his sentence.
Your Honor.
I've never seen the military get involved with somebody who's already been sentenced to prison, Judge. I think that's
no. I mean,
that's misleading to him to suggest.
You can let them know that the court will reconsider if there's no objection from the state, his going to prison, if he's signing up to go into the military.
Your Honor, that's what they're waiting for you right now, because they're waiting for you to zoom them in and talk to them, for we could get all that situation. I could get it.
Your attorney about that, and the court will consider it.
And
so Mr. Martinez will take care of that for you.
Even if I could hire the stipulations or anything to be able to stay out and do, because I was doing right, Your Honor. I was literally doing right, like I was supposed to.
Yes. All right, just speak to your attorney about that.
You can talk to him, right?
No. Your Honor, may I tell my fiance bye, please?
They are in charge of security. All right, did you have contact with your attorney? He said what?
He won't be able to make it. He actually scheduled like 2 days ago and nobody responded back.
No, that's not how, let him know that's not how things are rescheduled. He needs to file a motion for continuance or come in. So we're recalling your case from October 30th, and he needs to be here. All right, they'll give you a reset form. I'm sorry you were sitting here all day. All right, state on Miss Moore.
Okay.
All right, today is the plea deadline date. Have you all reached an agreement, or is this going to jury trial?
Your Honor, we have an agreement, Your Honor.
All right. And what is that agreement? Do y'all have an agreement?
Yes.
Yes. I believe it's, hey, could you repeat the agreement for the court? Put it on the record, please.
Miss Moore, can you unmute yourself?
Yes.
Did you reach an agreement with the state?
It was 2 years deferred education probation.
All right. So you all need to do the paperwork. So I'm going to put you in a breakout room. The coordinator will be in the breakout room with you. You all need to complete the paperwork, and we're going to take this matter up today.
Judge, is there anyone I could take it up in a setting, please?
I'm sorry, what?
Can I take this up at a later setting in maybe a week or two?
No.
Okay.
And the reason why it has been very difficult to have people appear in court when they're supposed to appear in court. Then when I give people a Zoom link, what ends up happening is people are still not on time. This case will be resolved today. If this case is not resolved today, then you will be in jury trial on this case next week, and everyone will be here at 9 a.m. I'm going to send you to breakout room number 2. Ms. Ferguson will meet you there. She will get your email address so this can be completed. Do you understand, by signing that plea of consent to appear by video, you're giving up your rights to appear in person?
Yes.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor, we do waive the reading.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Did you review the court admonishments, Ms. Moore, with your attorney? Did you understand it and electronically sign it in all the appropriate places?
Yes.
Did you understand you're charged with theft of property less than $2,500 with 2 or more previous convictions? That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence state's exhibits 1 and attachments. Court has reviewed the same. The court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
No, Your Honor.
All right. Are you currently employed?
Yes.
What do you do?
Home health care.
I don't allow people who are on probation in my court to do home health care. The only way you're allowed to continue employment as a home health care provider, if 1, your employer sends the probation a letter stating they are aware of your criminal history, and number 2, people that you're providing care for, their families send letters stating that they're aware of your current status with these previous convictions.
Okay.
Do you have any minor children?
No. Well, yeah, I have kids. I have 2 daughters.
And what are their ages?
16 and 11.
All right, this is what the court is going to do. There's a $1,000 fine to be prorated, regular reporting by Zoom or in person, regular random UAs, no contact with HEB in San Antonio. That's any HEB in San Antonio, Texas.
Okay.
Proof of employment within 45 days, no employment as a home health care provider or with minors. Field visits 1 time per month for 4 months. 150 hours of community service restitution. Once parenting classes are completed, 50 hours will be deemed satisfied. The
Your
remaining
Honor.
100 hours will be completed once she completes the anti-theft course. Yes, sir?
I thought the agreement called for no contact with the HEB where she was arrested, which is in San Antonio. She lives in Austin.
That's not a part of your agreement. That's outside the agreement.
So no contact with all HEBs are outside of the agreement. That's what you're saying?
No, what I'm telling you is you didn't agree to a specific. The only thing that you've agreed to is that she has $1,000 fine that is probated and that I give her deferred adjudication. Everything else is outside your agreement. You cannot bind the court to those agreements. What I have said is she is not allowed to go to any HEB in San Antonio, Texas.
Okay. Okay.
All right.
And then I have a quick question. So I will have to quit my job, right?
Unless you have an employer who's willing to write a letter and say that they are aware of your criminal history and list these items as a part of your criminal history and that they have no concerns about that. And whoever you are providing home health care to, that their family member is aware of that and they send a letter as well.
Okay, so the people that I work with,
we could talk about it after.
Okay.
But Judge, I'm clear. I will communicate with her how we can satisfy your requirement.
All right. And where is she asking that her probation be transferred to?
Is it Travis County, Your Honor?
All right. Transfer to Travis County.
Court. I'm glad. Yeah, Travis County.
Court will sentence you to 3 years deferred adjudication.
Sorry, I thought it was 2.
I thought it was 2.
All right. So let me explain something to everybody. Number one, you do not get to determine what the length of probation is. That is solely in the court's discretion. You all can make recommendations to the court, but anything that's below this line on this piece of paperwork, that is not a part of your plea agreement. And it actually states, note, the parties are not allowed to make binding agreements regarding the length of community supervision or the terms and conditions of community supervision, which are totally dependent upon the court's discretion. The following recommendations do not constitute part of the formal plea agreement. And what is listed? 2 years for the length. TAP evaluation, 150 hours of community service restitution. I don't have to give her 150 hours of community supervision. I could give her, restitution. I could give her 300 hours. The no contact with HEB at Valley High Drive. I can say no contact with HEB throughout the state of Texas. The anti-theft course, I don't have to give that. The reason why I am giving her 3 years deferred adjudication, because I don't want anyone to think that I'm just arbitrarily giving people things. She is charged with theft of property under $2,500 with 2 or more previous convictions, which means that she's been stealing 2 or more times before she even got to the felony level. And then according to the stipulations that y'all entered to, she went into HEB, took a Ninja ice maker or Ninja smoothie maker and just put it in the cart and walking it past all points of sale. And it's not as though she's 18. And if she were 18, it would still be wrong. But at some point in time, people should learn you're not allowed to take items from stores unless you paid for them. So should she be getting a minimum of 2 years for on probation? No.
Okay, so I have a question. Because at first they was offering me sir.
Your Honor.
Probation. Is there anything else with regards to sentencing?
No, Your Honor. We're going to do the deferred probation because it prevents her from being a
Now
convicted
I'm
felon.
asking probation. Probation, are you requesting or recommending anything else? All right, so it will be the felony theft course. Once that's completed, 100 hours will be deemed satisfied.
Thank you.
If they do go and try to.
Yes.
That's enough.
All right. Is there anything else you need from the court to be successful on this probation?
No, Your Honor. Well, no.
All right. Could you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it electronically?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. I'm going to send you to the breakout room and probation will go over conditions with you.
Your Honor, am I excused?
No, you are not. You need to go into breakout room.
Your Honor, it's been some time since the incident. Since something happened recently, she is in a better place now in her life. She's employed. She's 9 months pregnant. She's set to give birth here in about 12 days or so. She's in a good place, and she thinks that she has learned her lesson and will definitely comply with probation.
All right. So this is the third time she's probably learned her lesson from stealing. Why do you keep stealing?
Before I wasn't in a better position than what I am now. And that was something that I picked up in a bad habit.
What, a bad habit of stealing?
Yes.
How do you develop a habit for stealing?
It was just something that I chose to do. It was a choice. And
but I mean, I'm just trying to figure out, how do you develop the habit for stealing?
It just happened, and
well, I mean, did you all plan? Did you all say, hey, let's go to Don and Ben's and take tequila?
No, it wasn't anything like that. Like I said, I was in a bad predicament and I was using that to like pay rent or do any, just making any
No, I don't know. Because, and let me just explain to you why I don't realize that.
Understand.
Because people will spend money on their wants, but not on their needs.
Right.
And what I'm reading in here, everybody in the vehicle was dressed to the nines. So obviously there was money for clothes, there was money for hair, there was money for nails, there was money for gold, there was money for gold grills, but then people are saying they're stealing for other things that I don't understand.
Right.
And then going to Don and Ben's, the officer said that the car smelled of marijuana, and you all just went to Don and Ben's grabbing tequila. So I don't understand when people say, oh, I needed rent. Who's out here buying stolen tequila?
I don't smoke, so I don't know.
No, I said, who's out here buying stolen tequila? Did you take orders where you just say, hey, anybody want tequila? Because it's saying that you took
6 bottles.
Yes, of tequila, 2 coconut bottles, reposado.
Yes.
And
regular.
Yeah. So see, she remembers. So why? So that you all could drink and have a good time. How old are you?
I'm 28. I was 17 at the time, and that was just how I was making my money. There's no excuse for it. I'm not making no excuse for it. And like I said, that's something that I'm not doing anymore.
And the people you were with, this Latasia Bateman, who is that?
Just a friend of mine, or was a friend of mine.
All right, and who is this? I guess their mom named them T.I. Era Barber.
Yes.
Who is that?
Just another friend.
What does T.I. stand for? Is that their name, T.I.?
I think it's T-Era.
Oh. The officer then put an apostrophe. Okay.
All right.
All right. Court is going to sentence you to 2 years in the state jail facility, suspended and probated for 3 years. If you were drug tested today, what would the results be?
I'm going to be clean.
Okay. There's to be regular UAs, regular reporting by Zoom or in person. Are you employed?
Yes, ma'am.
What do you do?
I work for home health.
Doing what?
Pretty much like assisting and aiding. I'm with DSP.
What does that mean, assisting and aiding?
I pretty much help feed, change clothes.
A credential, or you like a CNA?
I'm not a CNA. I'm just a caregiver.
No, do you go into people's homes and do this? I don't allow people on probation in this.
This is the actual. It's like a nursing home. It's not just like a home. It's a it's a nursing home, like an actual.
So she doesn't go on.
So I don't go into people's houses. It's a actual facility.
All right, I'm not going to allow you to continue to work there unless I receive a letter from your employer stating that they know what you're charged with and you can still work there. And then the people that you're taking care of, they either need to sign something or their relatives need to know that you're working there. All right, then their relatives need to know that you're working there. That's Ms. Abrams, that's what I'm ordering. So proof of employment within 30 days. No employment with minors.
She is on maternity leave right now, so I don't know if you might be able to extend 30 days out a little bit longer than that.
Oh, just speak to probation about that. I consider myself to be reasonable.
Just thought I'd put that on the record.
I appreciate it.
Because it may be, 30 days from 2 weeks and then.
Oh, trust me, probation will say she's on maternity leave. And I'll say, okay. There's to be no employment as a home health care provider in someone's residence. And also, she's not to be a home health care provider at a facility without a letter from the employer stating that they are aware of her criminal history and she's allowed to work there. And the family members of whoever she's caring for is aware of a criminal history and they have no objection to their working there. Field visits 1 time per month for 3 months. 200 hours of community service restitution. I'm going to order parenting classes. Once the parenting classes are complete, 100 of those hours will be waived. And then I'm going to order the theft course. Once that's complete, the remaining hours will be waived. Probation, is there anything else? Is there anything else you need from the court to be successful?
No, ma'am.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Oh, and I'm sorry, just one other thing. There's to be no contact. Lastasia, Lastasia, Bateman, Batman, and Tierra, Tierra, Barber, Barber. All right, because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, good luck to you. If you need anything, let probation know. If you feel as though they're not addressing it, you can always come back to the court.
Thank you.
All right, you're welcome.
Yeah.
Just remain in court